How the CARES Act will affect health and retirement plans. My name is Paul Carl, and I'm responsible for new business development for Haran Wealth. Thank you all for joining us. At Haran, we offer solutions to three of the challenges Americans will face for the next several decades. We provide access to high-quality, affordable health care through the bridge of insurance. We provide planning and investment guidance to build wealth for your retirement and ultimately for the next generation. We design insurance products and services to mitigate the risk of living too long, dying too soon, or becoming disabled. We realize you've been bombarded with emails and articles on everything COVID-19, and it is overwhelming. These are uncharted waters for all of us. Today, we'll provide explanation of the new CARES Act relief for retirement plan participants and health plan changes that have occurred as a result of COVID-19. We'll be discussing a practical approach to handling benefits during periods of furloughs and layoffs. We believe that this webinar, you'll have a much better understanding of the recently passed legislation that will assist you in making educated decisions on changes that will have an impact on your organization and your employees. Now, what I'd like to do is introduce to you my good friend and colleague, Shelley Hodges-Konis, the Director of Compliance for Haran Wealth. Shelley?
Thanks, Paul. I have the pleasure of introducing Lee Geiger and Lindsay Barnett, both partners at Graydon Law. Lee is the chair of the firm's Labor and Employment Group. He provides clients with prompt, practical, and usable legal advice. His goal is to make your problems become his problems. That way you can focus on running your business and sleep a bit better at night. Lee helps public and private employers of all sizes address employee issues. Lindsay Barnett is the chair of the firm's Business and Finance Department and was previously the chair of the Benefits and Compensation Practice Group. One aspect of Lindsay's practice involves counseling employers with respect to the development of employee benefit strategies. Lindsay is also the vice chair of the Financial Services Group and chairs the ERISA Advisory Services Subgroup. She assists financial institutions to ensure the services they provide to retirement plans are compliant with the law. One of the things I love about both Lindsay and Lee is that they can make complex issues seem much more digestible and understandable to most of us and how they apply to our roles. Lee and Lindsay, we appreciate you offering your insights and expertise to us, to our clients, and to our friends. We know you are both extremely busy given all that has transpired these last couple of weeks. For those that have questions during the webinar, please submit them through the Q&A function. We will answer as many questions as time permits. And with that, Lee, I will turn it over to you. Thank you so much for joining us again.
Thanks to Shelley and Paul. Really appreciate it. Thanks to everybody at Haran. This is we're going to have a little bit of fun today, believe it or not. With the we're going to try to make this interesting. And Haran is a great partner to work with. It is my pleasure to present with Lindsay today. I'm kind of the bait and switch here a little bit. Lindsay asked me to talk just for a few minutes on updates with the FFCRA and things that have changed since last week when our partner Julie Pugh spoke to you. So I'm going to speak for just probably about 15 minutes or so, and then the real reason that you signed up for this was to hear Lindsay talk about the benefits stuff. So, and because God has a sense of humor, you all need to know, but especially Lindsay needs to know that my Wi-Fi just died twice in the last 2 minutes, and I do not have the slides pulled up. So, Lindsay, you're definitely driving, and I guess just do your best. I'll tell you which slide I think that we should have up. So,
hey, we need to make it more of a comedy of errors. My internet just got kicked off too, so they don't see my screen right now. I am currently logging back in.
Okay, is anybody at Haran able to run the slides? Okay, with that, we're just going to talk for a little bit then, and hopefully somebody will get their stuff back up. So essential businesses is what I want to cover first. And most of the people, if you're listening to this, you probably are an essential business. We've had very few clients that have conceded that they are not essential businesses, because most of our businesses somehow, some way make the world a little better place and are essential to the operation of our country. So if you are an essential business, here are 4 quick things that you need to know. And we will be making sure that you get the slide deck from this so that you will have these slides. First thing is obviously know whether your business is essential. The second, assuming you are an essential business, make sure that your employees have letters that they can keep in their car with them that says, I work at XYZ company, and we are an essential business, and here is why we are an essential business. I don't recommend that you list the names of your clients or your customers to establish that you're an essential business, because that's confidential information. But it would be sufficient to say, yes, we're in the manufacturing industry and we're important to the supply chain. I would also reference Governor DeWine's or any other governor, whatever states you're in, reference the state's orders about essential businesses. The next thing you need to do is make sure you've prepared your front office staff for a surprise visit from the health department. They are making those visits. They are not random visits. All the ones that I have heard about from our clients getting tagged is an employee or an employee's family member complained that the business was still operational. So make sure that you've got somebody that's right there to greet the health inspector at the door, that knows why you're an essential business and is prepared to show all of the things that your company is doing to demonstrate its essential business status. With regard to the letters, we have helped many clients prepare the essential business letters. Talk to whoever your employment counsel is, and they should be able to help you with that. Next thing that we've got, Lindsay, I don't know if you're up yet or not, but there is a chart that we will have pulled up that lists the reasons why someone would get paid sick leave or expanded family medical leave. The chart has 5 boxes that coincide with the first 5 elements of the paid sick leave law. So we're talking about basically 2 categories of paid sick leave. The first category is for the employee either being ill or having some type of an illness related to COVID-19, or they're seeking, they have symptoms, they're seeking a medical diagnosis. So, or they're subject to a local quarantine. So those are the situations where an employee would be subject to and benefit from the paid sick leave laws. The next part are where employees get paid at 2/3 of their pay, and that category is essentially they're caring for someone else. Either they're caring for an individual who is subject to an order described in the law. So in other words, they're caring for somebody that's got COVID-19 or has been ordered to quarantine, or they're caring for a son or daughter of the employee because their child has been their child's school or daycare provider has been ordered closed. A couple of tweaks since last week that you need to be aware of in those items is that when we talk about the number 4, that they are caring for an individual who is subject to an order, individual, that definition has been narrowed, so it can't be the random guy that you picked up, last week at an event. It can't be someone that you've never met before and suddenly you're going to try to get paid sick leave. Okay, it's got to be someone that you have a close relationship with. Likewise, since last week, there's been some better news for employers on the caring for the son or daughter exemption. One question that a lot of people said was, hey, my employee has a stay-at-home spouse, and the stay-at-home husband or stay-at-home wife is still there staying at home, and yet my employee is claiming that because the school is closed, they also need to be home. And the response to that is no, that is not an acceptable reason for the employee to be using paid sick leave. And the IRS is not going to allow you to take the tax credit in that scenario. Last thing that I'll tell you about this grid when you see it is that it's a great grid. There are about 1 million great grids that are out there. They're all a little bit different, but I haven't seen any yet that are just flat wrong. We have run into issues with clients that start working off of a grid, and then they hear from another HR provider, hey, you need to look at this grid or that grid, and they do, and then they get confused. So my advice would be stick with the grid you've got and find one that you like and stick with it, kind of like, you know, you got to go home with the person you brought to the dance. Okay, so let's go. Lindsay, are you back up yet?
Yeah, Lee, they can see the screen.
Okay, let's go to more what's changed. Let's go to the slide that says what's changed since last week.
Got it.
So another thing that's changed, it just changed over the weekend, is that the Department of Labor expanded reasons that individuals are eligible for unemployment. So these people previously were not necessarily eligible for unemployment. There's 3 new reasons. 1, the employer temporarily ceases operations due to COVID-19, preventing employees from coming to work. That wasn't particularly shocking, but the Department of Labor clarified it. Number 2, an individual is quarantined with the expectation of returning to work after the quarantine is over. So that could be a situation where someone has already exhausted their paid sick leave, but otherwise is not entitled to payment. This would allow those individuals to continue to be paid under the unemployment statute. And the third is an individual leaves employment due to a risk of exposure or infection or to care for a family member. So this is a situation where the person does not otherwise check one of the boxes for the reasons for the sick leave, and they would be entitled to unemployment per the very recent Department of Labor stuff. Okay, Lindsay, let's hit the next slide. I'm going to fly through some of these so that you can hear Lindsay talk about the stuff, the benefit side of all of this. How much combined FMLA or emergency FMLA do they get? The answer to that is 12 weeks. It is a combined 12 weeks. If employees have already taken 6 weeks, they only get 6 more weeks. Also remember that the emergency FMLA only kicks in if the employee is off of work due to the school or daycare center being closed. Next thing on that list, intermittent leave. A change since last week is that intermittent leave now must be mutual. At last week's time, intermittent leave, the company could decide, yes, you're going to take this intermittently. Now it must be mutual. You can only take intermittent leave for reasons 5 or 6 on the chart. That is, you're carrying, only for number 6 if the person is actually coming to, or let me start over. You can only do it for number 5, which is the sick leave to care for a child who is at home because school is closed. If you're going to and from work, you can do intermittent sick leave if the person is able to work from home. So in other words, if someone has COVID-19, they're working from home, but they're exhausted, they can only get 4 hours in a day, it's totally fine for you to pay them 4 hours of regular pay and 4 hours of sick pay. Just make sure that you've documented that. The next one, furloughed, laid off, employee eligibility. Furloughed employees are not going to be eligible for the paid sick leave because they are not off of work because of a COVID-19 reason. However, if they are off of work because the governor has shut your company down, so in other words, we've got a quarantine type of issue, you're a non-essential business, then this is a change from last week. That reason number 1 is going to kick in and is going to allow paid sick leave. Just, you need to distinguish, why is the person off of work? Are they off of work for lack of work? If it's due to lack of work, then the employee gets unemployment. If they're off of work because of a COVID-19 reason, then they are eligible for the paid sick leave. Okay, let's hit the next slide. Can we supplement with other types of leave? Yes, at the employee's option. The employer cannot force that. So we're only talking about categories 5 and 6 in that chart. So you're home caring for another individual, or you're home caring for a kid who's not at school. Those people are only getting 2/3 of their pay. They are permitted to supplement that with with their existing sick bank, vacation bank, whatever. I have gotten a lot of questions from clients wanting to know if employees can supplement their unemployment with existing sick banks or existing PTO. And my answer to that is yes, but I'm not sure why they would want to. Because if they supplement, the Unemployment Bureau is going to reduce the amount of money that the employee gets from unemployment. So they're unnecessarily depleting their personal bank of time. Next one, what documentation is needed to support leave and tax credits? That's going to be, at this point, use your common sense. Get doctor's notes when you can. Get some type of internet proof that the kid is not in school. I don't care if it's a note from Miss Mary, your kid's preschool teacher, that says that they are that the school is closed. That's enough, but you got to have something. Who is a son or daughter? This definition expanded over the last week, and the definition of son or daughter is now consistent with regular FMLA. So that means that in loco parentis situations exist, which is really just Latin for anybody that acts as a parent, even if they are not the actual parent, could be covered in that situation. Let's fly to the next slide here. Other common questions that I've gotten in the last few days: headcounts before and after layoffs. Just remember, if you were 500 people before the layoffs and you laid off 100 folks, you are now under 500 and you are covered by the paid sick leave law and the emergency FMLA law. We've run into several clients that thought they were immune from this and realized that, oh, now I need to start offering to the remaining employees. There is, next bullet here, there is a healthcare exemption. The healthcare exemption was much, much broader than expected. And so if you are in healthcare, you should talk to your employment counsel, because there may be ways for you to limit the use of paid sick leave and the use of the family medical leave in certain circumstances. Lots of weird rules around that, but know that that option exists. PTO payments to people on layoff, we've already talked about that. And temporary employees, they're going to get the squeeze on this. There's still not a ton of guidance out there from the unemployment or from the Department of Labor on this, but temporary employees do count for your payroll for purposes of determining the number 500. But they are not on your payroll for purposes of being paid sick leave. And odds are pretty decent that the temporary agency that they're working for has more than 500 employees. So that's a really long way of saying that I think, and we don't have any proof of any of this yet, but I think that temporary employees are going to get the squeeze and are not going to be eligible for any type of paid leave. Let's move on to the next slide. Small business exemption. I'm just going to fly through this one, and Lindsay actually hit the next one that says what employers are covered. In that slide, those are the elements, and if you are a small business under 50 employees that suddenly finds yourself subject to these laws, you're going to want to pay close attention to these. There are possible exemptions. You want to talk to your employment counsel and probably your accountant about whether or not you would be eligible for an exemption under these circumstances. Note, though, that the exemption is only for the care for a child whose school or daycare is closed. If the employee has COVID or is caring for someone that has the coronavirus, then they are still going to be eligible for the paid sick leave. I'm going to do one more slide and then I will turn it over. The next slide is the don't forget your training. I've had to remind some great HR people over the last few weeks, hey, you've got this, right? You've been training for this, some folks for 10, 20, 30 or more years, okay? You know what's right and wrong, and don't get caught up in the hysteria here. Don't suddenly start releasing names of infected employees, because you would never disclose the name of an employee who had another illness. You would never say that Mary has breast cancer or that Scott's got prostate cancer. And so now is not the time to start disclosing the names of employees. Remember, when you're doing layoffs and reductions in force, that you still need to do the adverse impact analysis. Now is not the time to get rid of that 30-year employee that otherwise has had a good, clean record, but is kind of a pain in the backside. If you're going to get rid of that employee, you need to make sure that, that there are good documented business reasons for making that decision. And then the last thing that we've got, and Lindsay, you can just flip them up if you want, we've got to-do lists in here for people to kind of check off the boxes as they are going through their process, and these slides will be sent around to you, so I'm not going to go through them all, but just make sure that you've got your ducks in a row here. Make sure you've got your policies posted. Make sure that you've got a new policy. Make sure that you've got forms. If you don't, talk to your employment counsel, and they probably have forms that they can get to you. And with that, I will turn it over to the benefit side of this.
We have one question, Lindsay, before you jump in, and it was around an employee having a written statement from their doctor recommending that they not report to work because they're high risk. And the question is whether or not employers have to allow that because they've not actually been quarantined or diagnosed with COVID-19.
So it's going to be on number 2 on the chart, and that is that the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. And so in that situation, I think probably yes, you are going to have to require or to allow the person to take the paid sick leave in that scenario. So it's kind of disgusting that I already know these numbers kind of in order. It's hard to believe for all of you as well that 3 weeks ago, none of this existed, and a month ago, COVID-19 was something that existed in China, and we weren't really worried about it in the U.S. So, and Shelley, unless there were any other questions, I will turn it over to Lindsay. She is the best attorney that I know in terms of explaining complicated benefits issues. She is my go-to at the firm for all things benefits related, and clients absolutely love working with her. I think most people on this call probably have worked with Lindsay before. Without further ado, here's the real reason that you signed up for this.
Yep. Thanks.
All right. Well, you're too kind, Lee. I appreciate that, and I really appreciate Lee jumping in. Thanks to Haran again for having us. I asked Lee to join us primarily because 90 minutes is a long time to listen to me talk. I could talk for days on this, but I won't. So we're going to break this up a little bit. We're going to talk about health plan issues, and then we're going to talk about retirement plan issues. Well, a lot of what Lee talked about applies to employers with fewer than 500. What I'm going to talk about really applies to all employers that are offering benefits. And so, like Lee just sort of wrapped up, what have we all experienced in the last month? We have experienced a lot of change, right? The picture on the left that you see there is Graydon's offices. And 1 month ago, I was happily sitting in my orange office working away, and that isn't me below because I haven't looked decent enough to take a picture of myself in the last month, but that's similar to my work arrangement now, and I'm sure it's similar to many of you. So while all of our experiences changed, all of our companies have changed too, right? And the benefits laws are changing so quickly that it's hard to digest them and get them communicated to clients. So, they've come in large waves in here too. They're not all in the same piece of legislation. A lot of what Lee spoke about was in the Families First Coronavirus Response Act. It was largely employment and leave related, but it did have an impact on benefits. So we'll touch on that a little bit. And then just 2 Fridays ago on March 27th, Congress passed the Coronavirus Aid, Relief, and Economic Security Act, which we affectionately refer to as the CARES Act. We've had some other guidance from the IRS, DOL, Ohio Department of Insurance, DeWine, and here in Ohio, DeWine's daily 2 o'clock press conferences. So I'm going to try and boil these things down for you, and then also sort of give you the spin on what we're seeing companies do. I'm going to start, though, by talking about a furlough versus a leave versus a layoff versus a termination, because we get this question a lot from companies. Unfortunately, I'm sure many people on this call have already had to make the tough decisions and may have been forced to take one of these actions with their employees, whether that's action was mandated by the government or, just your business model. And unfortunately, probably more of you will need to make the decisions in coming weeks. And so I think that it's important to know that the terms furlough, leave, layoff are really kind of terms of art. Companies don't always use them the same way. Sometimes in different industries, they mean different things, union versus non-union. So I thought I would go through sort of just high level what we kind of think the common definition is, but really you need to think about your situation. And the reason I say this is depending on an employee's status, depends on whether they get to continue benefit coverage or not, or if they're entitled to a distribution. And so when I think of a leave or a furlough, there's an intended return. You're not intending to terminate employees. They haven't had necessarily a severance from employment, but usually it is a shutdown for some period of time with the intent to bring the employees back when things, situations change. A layoff often is closer to a termination of employment. Oftentimes on a layoff, you are terminating the employees from your system. You may intend to bring them back if things get better in the future, but there isn't an immediate intent to do so. And then a termination is truly that. The employee has severed from you and no longer has an employment relationship. So I just want to start to go through those key terms. What I always tell clients, the most important thing to do is when you're analyzing, is this person on a layoff or a leave or a furlough, have they had a termination of employment, is we must be consistent. We cannot treat an employee as an active employee for one purpose and then a terminated employee for another benefit purpose, right? You don't get to have your cake and eat it too. And so if we're treating the employee as an active employee, let's say for health insurance, then we can't treat them as terminated in our retirement plan so that they could get a severance from service distribution or so that we didn't have to make an employer contribution for them. So when you're thinking about a particular benefit and whether someone's eligible for it, don't think about it in a vacuum. Think about it in the broader scope. And then oftentimes, especially on the welfare plan side and the health side, whether coverage continues is going to be governed by the terms of your plan document. So if you're unsure, check your STDs. If your STD is not clear, now's a great time to update it to make sure it reflects what you want to do. So with that sort of employment background and then this layoff, leave, furlough, termination background, we're going to jump into health plan changes. Like I said, a lot of different changes coming at us from a various amount of sources and multiple acts. Some are must-dos and some are may-dos. And so I will hopefully point that out on each slide to you, but not all of these are mandated. These apply to plans of all sizes, regardless of whether you're self-insured, fully insured, level funded, whether you're small group, large group, whether you, most apply to grandfathered health plans. If anybody on the call still has a grandfathered health plan, we still have a few out there in our client base. And so the first one of these that we're going to talk about is a must. Okay, I have a must and a may on this slide, but this relates to COVID-related expenses. And so as part of the FSCRA, which Lee talked about, the benefit piece, one of the benefit changes that was in that act was that no health plan could impose cost sharing. That would be deductible, copay, coinsurance, nor could any service be subject to prior authorization if the service was for testing. Okay, so this means COVID testing must be paid first dollar by all group health plans. The testing, the cost of the testing includes the cost of the office visit. That is whether it's in the office, telehealth, urgent care, they get it done at the emergency room. So if someone goes to the emergency room to get the COVID test, you have to cover 100% first dollar that emergency room visit. However, if the visit does not result in a test being done, then the visit doesn't have to be covered. Now, most of your plans probably would still cover the visit. It would just cover it the way that a normal visit is covered. So if they went to see their primary care doc, it would be billed with that, deductible, copayment, coinsurance, or if they went to the ER, it would be paid that way. That is true, even if the person goes, I know some people personally who have went that have been symptomatic and their doctor has said to them, yeah, we're almost certain you have COVID. but you're not high risk, your symptoms aren't severe enough, and we have limited tests, and we're basically not going to use one of them on you, and they send them home. So that visit could be paid, could be subject to cost sharing, unlike the if a test had been administered. Okay, so this is a mandatory. All plans should already have changed for this. This is in effect until the COVID national emergency is lifted. So plans can go back once the national emergency is lifted. Plans will be able to go back to charging for the testing. Okay, so the next piece down on the slide is a may. Plans may pay for all COVID-19 treatment at 100%. So this actually came out in a notice from the Internal Revenue Service, because what this really relates to is, you know, for your non-high deductible health plans, you can pay for anything you want at 100%. If you're self-insured or if you're fully insured, you know, the insurer is going to offer that. But for high deductible health plans, the rule is that in order to meet those requirements to allow the participants in it to be HSA eligible, then the plan can't cover any expenses that aren't preventive prior to the individual meeting that minimum deductible amount. Well, the IRS came out and said, we're going to allow for all treatment that is related to COVID to be covered 100% without sort of blowing up the plan's high deductible health plan status. Most insurers have implemented this for their fully insured products. So if you're curious, if you have a fully insured, if you offer a fully insured product and you're unsure if your plan is doing this, you know, you want to check with your insurer. But my belief is that at least around here, Anthem, Humana, United Healthcare, I believe Aetna and Cigna have all put this in their fully insured book of business. We've also seen some ASOs on the self-insured side trying to sort of push or coerce employers into offering this. I have seen employers push back on this for a variety of reasons. And I know at first glance that may seem cold-hearted, but one of the reasons that one comment that an employer made to me that sort of struck home for me is, yes, this is an unexpected cost if you get diagnosed with this, but at the same time, a cancer diagnosis and treatment for that, or a heart attack, or, you know, many other health conditions are unanticipated costs to an individual. And so why should these people be, you know, treated differently? So not trying to convince you either way, just know that that's out there. If you're self-insured and haven't made a decision yet, it's something you want to do in short order here. There isn't, interestingly, an expiration date in the notice. So while the must pay for testing expires when the national emergency is listed, the way the IRS notice is drafted is this will go on forever. I doubt that to be the case. I imagine at some point the IRS will come out and say, you know, you can no longer pay for treatment at 100%. Okay. So the next one was a result of the CARES Act. This is the act that was passed and signed into law on March 27th. And what it does here, and this only applies to, so this bill applies to fully insured and self-insured. It would not apply to grandfathered health plans, though. And so those grandfathers, if you're grandfathered, you can ignore me for the next 15 seconds. But here, all non-grandfathered health plans must cover preventive services first dollar, 100%, whether you're a PPO or high deductible health plan. That was an Affordable Care Act change. It's a decade old now. And what is considered a preventive service is determined by the U.S. Preventive Services Task Force. And they update that list periodically. And then generally, a plan has a one-year period to begin covering anything that the U.S. Preventive Services Task Force recommends with a rating of A or B. You have 1 year to start covering that service as preventive under your plan. Well, you know, they want all of us to be vaccinated for this as soon as they have a vaccination ready. And so the CARES Act requires all non-grandfathered group health plans to cover whenever this vaccination, which we know, if you watch the media at all, you know, is being fast-tracked through every process. I'm trying to get one up and developed and approved. Your plan will need to be up and running and covering it within 15 business days of the recommendation being made. So this is just going to get added to the platforms, and so I just wanted you to be aware as participants start asking when this thing does become available. Okay, so the next item is telemedicine. And telemedicine, there's been a big shift. I mean, to talk about how in the last several years, more and more plans are offering telemedicine or telehealth benefits. And a lot of times it's just through a certain service. Like your Anthem plan, you may be able to call into Anthem's telehealth provider and get seen. You know, very few from, at least in my experience of the doctors that my family sees, doctors were actually offering telehealth or telemedicine. And in the last month, I mean, I think every doctor I've seen in the last decade has sent an email to me saying, you know, we will see you via telemedicine. I know my children's pediatrician that never wants to see you for any cost in the office is doing telemedicine to try and keep people, you know, quite honestly, we're trying to, it's another way to stop the spread, to try and keep people at home when possible. And so given the, you know, vast increase in telemedicine being offered, the CARES Act provides that all high deductible health plans are eligible to pay any telehealth expense prior to the deductible without jeopardizing HSA eligibility. So what we first thought, prior to the CARES Act being passed, what we thought was, given the fact that the IRS put this notice out saying you could pay for all treatment or, you know, diagnostic care or testing 100% without blowing high deductible health plan status if it related to COVID-19 symptoms, that it would just be those telehealth visits that a plan could pay 100%. Well, I think a lot of it was, how do we know if the visit was or wasn't? And so, you know, if someone's at home and they're experiencing a cough, but the doctor ends up saying, no, it's just a common cold or the flu, or, you know, how is that really distinguished? So I think from an insurance coding perspective, what they're saying is, again, this is a may, but high deductible health plans may pay for all telehealth services 100% without applying a copay or coinsurance before the deductible without jeopardizing an individual's HSA eligibility. This is limited relief. This is only for plan years that begin on or before December 31st, 2021. So for your calendar year plans, this is going to end December 31st, 2021. Let's say you have a July 1st plan year. You will be able to pay for telehealth if you choose to at 100% all the way up to June 30th, 2022. So again, that was a CARES Act change, and that is a may, not a must. Okay, so this next change is also a may, not a must from a legal perspective. But what I'm experiencing, what a lot of my clients are experiencing is operationally it's a must. So what do I mean by that? Well, those of you who have been dealing with your plan's benefits, health benefits for a decade or more may remember that back in the day, prior to the Affordable Care Act, health FSAs could pay for over-the-counter drugs, and virtually all of them did. And then when HSAs came on the scene, you could reimburse yourself if you had an HSA for over-the-counter drugs. And then the Affordable Care Act changed that. And so in the 2011 timeframe, HSAs ceased being able to reimburse or make distributions for over-the-counter drugs unless those drugs were prescribed. So if you had a prescription for the over-the-counter drug, you could get reimbursed from your HSA or your FSA. Well, the CARES Act decided to change this back. And so once again, over-the-counter drugs, even those without a prescription, so any of us could go to the store and pick up ibuprofen and be reimbursed from our HSA. Now, no action is necessary on the employer on the part of the HSA because the individual in HSA, remember, is not an employer plan. I'm not talking about the high deductible plan that goes with it, but the HSA itself is a savings account vehicle that's owned by your employee. And so, for those of you who are curious on your own HSA, you can start reimbursing yourself for over-the-counter drugs right now. For FSAs, though, the plan will need to be amended to permit this. This is an optional change. I have had several large employers who have said to me, we don't want to make this change right now. The main reason, quite honestly, that's with several people I talked to about it that didn't want to, it didn't have anything to do with not really wanting an employee to be able to use. It's their money. It's the employee's money. But it was more that there's so much change right now, they can't handle any more change, can't handle more communication on change, and they just wanted to pause on this one. But at least the one employer I got an email early this morning from said, oh, I guess you need to draft that amendment for me after all, because their vendor, a pretty large national vendor, said, we can't, our system is being updated across the board to permit this. And we can't cease it if you're using our debit card program. If you want to not allow it on your plan, you're going to have to go back to all paper reimbursement. And so this employer did not want to do that. They didn't care enough. They were looking for no change, and that would have been a bigger change than allowing this. So, you know, if you're not sure where your FSA vendor stands, you need to reach out to them. I've seen some even reach out to participants prior to the employer saying they were going to enact it, which has actually infuriated the clients. So the second thing that the CARES Act did around this, which I find, I really, and a couple of people have asked, I have no idea what the policy behind it is, and I really, I'm not sure I want to even look into it. But the law now allows menstrual supplies to be reimbursed from both an FSA and an HSA. So again, amendments not required on the HSA side, but on the FSA side, your plan will need to be amended to put these items in. Are you choosing to use them as reimbursable expenses? Okay, so we talked a lot about the EFMLEA and the new, you know, sick leave provisions, the expansion of the Family Medical Leave Act. And while I said that almost all of my slides would apply to employers at all sizes, this is the one exception, I believe. This is only going to apply to those individuals who are subject to the EFMLEA. That is really a mouthful and hard for me to say. And that is generally if you have fewer than 500 employees, if you're a private employer, and then some public employers. And so if you are subject to the general rules of the FMLA kick in, and employees must be eligible to continue coverage during the protected leave at active employee rates. Okay, this is true even if you have fewer than 50 employees and are not generally subject to the FMLA, but you're just now subject to this extended piece of the expansion of the FMLA. The other thing is that similar to your sort of standard FMLA, employees are able to drop their coverage if they choose to, and then be automatically reinstated when they return. So that's true even for non-payment of premium. And so if someone chooses to drop coverage when they're out on EFMLEA, they need to be reinstated in that health plan coverage if they come back immediately following the leave. So premiums during other types of leave. I get this question a lot. This is not a new question. This isn't a particularly CARES, COVID, coronavirus related question, but you're probably, you know, but we're getting it because there are so many leaves going on right now. So the question that we get all the time is, hey, I'm putting this employee on a leave, whether it's a medical leave, a sabbatical, all sorts of types of leave. Do I or can I continue their coverage? And so my first response always is, what does your plan say? Your plan document should talk about when coverage terminates. It should talk about whether a leave of absence that's not covered by the FMLA is a termination event. Oftentimes, documents say things cover employees for some period of time. It may say for the first 6 weeks, employees are covered. We have some clients that say for the first 8 weeks, you're covered at active rates, then you're covered for 8 more weeks at full cost, and then we terminate and put you on COBRA. So plans can say a variety of different things. And employers oftentimes have options of how they draft their plan, but it's really important if you're fully insured or if you're self-insured with stop loss that you don't be more generous than your document allows. Now, I say that with one caveat, and we're going to talk about my caveat on a new law change here in just a second. But the general rule, kind of pre-COVID through COVID, is if you're trying to be nice, that is great that you want to be nice to your employees. But the insurer can deny, or your stop loss carrier can deny any claims if you're more generous than what you have agreed upon in your plan document, because they have said they will provide coverage for that length of time, or they will provide stop loss. And so we routinely see claims get denied when employers are more generous. Another important point, if there's anyone on the line that has union employees, is what does your CBA say? You know, we see CBAs that provide things that coverage must continue on an unpaid leave of absence or on a furlough or a layoff, especially. Those are addressed. So always make sure you're looking at that CBA as well. Okay, so you may have some options. You oftentimes also have options. The document itself may not be clear on premiums. And so what do you get to do with the premium piece of it? So the first part of, my first part talks about, is the employee even eligible? The next part then is, what about the premium? Because I have an employee that's on unpaid leave and they're not getting paid. What do I do? Employers take a lot of different approaches. Sometimes they say you can continue coverage, but you have to continue, mailing in your premium. So that would be on an after-tax basis. If it's a paid leave or it's a leave with disability pay, sometimes the premiums, the premiums generally come right out of those payments. You could allow the employee to go into arrears. Obviously, the risk of that is when they may not come back, and then do you have any ability to recoup the money from them? So there are some considerations there. If you are trying to find a way to recoup or do those kind of things, I highly suggest you get counsel involved and make sure you're not violating state wage withholding laws, because they vary pretty drastically state by state. So this is my my caveat to the prior slide where I said your plan document governs. Your plan document always governs, right? Well, on March 20th, I know the date because it was my son's 4th birthday, and after working insane around-the-clock hours all week, I was hoping to take off a little bit early, around 3, to go for a long walk with him, when I heard in DeWine's 2 o'clock press conference that they made a change with health insurance in Ohio. So try explaining that to a 4-year-old why you can no longer take him to the park, but we scrambled and figured it out. What it is the health insurance. What DeWine said that day is the Ohio Department of Insurance was going to issue an order stating that no insurers, including stop-loss carriers, in the state of Ohio could cancel coverage for the employee not being actively at work. Okay. And so what does this mean? This doesn't mean that your plan is going to cover people that you truly terminate. So it goes back. And again, right now this is Ohio. I believe there are some other states doing that. I'm not up on all of the other state laws. I'm sure your rep at Herian could help you there if you have questions, if your policy is issued outside of the state of Ohio. But in Ohio, insurers and stop-loss carriers cannot enforce the actively at work provisions during the state of this emergency. So what does that mean? Well, if your fully insured plan document says that an employee who's not on FMLA is on an unpaid leave of absence, they lose coverage, the insurer cannot enforce that provision. The employee must be permitted to continue health plan coverage as long as the premium is still being paid. Now, that caveat has another caveat, because the second thing that Governor DeWine announced in his press conference that day was that insurers and stop-loss carriers could not cancel coverage if premiums were delayed by 60 days. So again, that began March 20th, so there was a 60-day delay. You could choose not to pay your premiums in Ohio for 60 days. I have some concern about this for employers who are still paying their employees. The reason being, and you'll see, you could read attorneys' articles on this that go both ways, that there is a plan asset concern. What that means is generally an employer must pay the premium or put into a trust an employee's premium if it's administratively feasible upon collecting it. The employer can't withhold a premium from an employee and then have use of that money. And so if the employer was still going to collect premiums from employees, yet they were going to defer, for cash reasons, defer the payment of the premium for 60 days, the employer would have use of that money. So if you're going to spend employee premiums as well, that's fine. But then the employees are going to have to double up, or the employer will be, unless you're going to give a premium holiday for this period. But the insurers are not giving a premium holiday. They are just allowing you to delay these payments. They will still be due later this year. So that's something, if you're in the state of Ohio, that you could consider for your fully insured plan or on your stop loss. Right. Okay, another quick thing just wanted to briefly mention is that we are seeing some of the insurers offer special enrollment periods right now. This, unless an employee has had a loss of coverage, or obviously the acquisition of dependent, marriage, birth, but the only situation kind of relating to this leave, furlough, termination, COVID, shutdown type thing is that that would cause a special enrollment right under HIPAA, right? All plans, all group health plans subject to the HIPAA special enrollment rights is a loss of other coverage. Well, if your employee, doesn't experience, they just didn't enroll in your plan, this generally wouldn't be a special enrollment event just because we're having a national emergency. Well, a lot of the insurers, probably with some pressure from the healthcare industry, are allowing people, they're opening up special enrollment periods so that your employees can enroll in your plan now mid-year. My understanding is that it's optional with most insurers, but also at the same time, and if an employee goes directly to the insurer and tries to enroll in your plan, the insurer may not stop them. So just wanted those of you with fully insured plans to know that some of the insurers are offering this. The reason we don't like mid-year enrollments the reason the rules are strict is because it creates adverse selection potentially, right? But we're in a unique time now, and so my thinking on it may be a little different than it would have been 6 months ago. Okay, so another thing really, there's been no change in the law, but we're getting this question a lot, so I wanted to bring it up, is health FSA election changes. The health FSA mid-year election changes are the strictest of any of the changes. So there are more expansive rules that apply to health plans, dental plans, your other Section 125 benefits, and the dependent care, which we'll talk about in the next slide, are even more loose. But with the health FSA, the IRS rules, there's a strict interpretation, and you have to have a mid-year change in status that is consistent with an eligibility change. And employers miss that piece all the time. Just because I have a reduction in hours doesn't necessarily give me, that is a change in status event, but that doesn't give me a right to change my FSA unless I lose eligibility on the FSA, okay? So be very careful in allowing health FSA election changes mid-year. Again, nothing's changed there, just wanted to bring that aware. Then dependent care FSA, and that is I figured I would use a picture of my own children in case you heard them screaming in the background. Thankfully, it's a nice day, and I can just see them jumping on our trampoline outside our window opposed to screaming outside my office door. But the dependent care FSAs also have not had a change. Now, I've actually had a client receive from a couple of vendors something saying, hey, we heard the rules changed with the dependent care FSA. So I spent some time making sure I hadn't missed something. But the law has not changed. However, a lot of your employees may have a right to make a mid-year change under your dependent care FSA. Most dependent care FSA plans permit a mid-year change for a change in cost. If an employee's daycare center is closed and they're not paying, they could decrease their election. Got a question yesterday, what if you paid for summer camp? Summer camps now are already getting canceled. If you paid, you were enrolled, and now it's getting canceled, that would be a change. And so, your employees probably do have some flexibility in regards to making mid-year changes there. The last thing on the health plan piece that I wanted to bring up is that, and Lee touched on this quickly at the end a little bit, HIPAA still applies. Privacy and security rules still apply. Lee was talking about it more on the ADA, just general confidentiality medical provisions. But under HIPAA, there are not any changes that are impacting group health plans on the privacy and security side. HHS did tweak some rules for hospitals, but they do not impact your group health plan. Your group health plan information must continue to be maintained as private information. It can only be shared with the company for the reasons that the plan can normally share. So that's plan administration, but primarily plan administrative functions. So that's sort of the last thing that I wanted to talk about on the HIPAA side. Shelley, I didn't know, do we have any health plan questions that you wanted me to address before we move on to the retirement plan changes?
I think there was only one around clarification of the over-the-counter drug change and questioning whether or not it also applies to HRAs or health reimbursement arrangements. So my understanding is that it would apply to health reimbursement arrangements, but that's up to the employer to include that provision in their health reimbursement arrangement plan document, and they likely need a plan amendment. Is my understanding correct?
Yeah, I believe that is correct. That it would apply to not only, I believe it also, I'm actually pulling it up right now. I can multitask. Yeah, it applies to even Archer MSAs. So it specifically says HSAs, Archer MSAs, health flexible spending arrangements, and health reimbursement arrangements. So it would cover all 4 of those spending types of vehicles.
Okay, great, thanks.
Okay, so that's my cue to move to retirement.
That is your cue.
All right, perfect. I'm gonna take a quick sip of water. All right, so we're gonna talk about the CARES Act first, because the big retirement plan changes came as a part of the CARES Act. And quite honestly, it almost feels insane that I'm presenting on this, I think 8 business days after this has been law. And many of you have probably already had to make the decision, or you need to make the decision in short order if you're going to make these changes to your retirement plan. I said to a couple people that I feel like as fast as this is moving right now, that I am giving drive-through legal advice. I feel like I am at a fast food restaurant and clients are speeding up to my window. I'm giving advice as fast as I can. They're speeding away. The next client's pulling up. They're speeding away. Yet I'm learning how to make the hamburger at the same time. And so, we don't have on the CARES Act provisions, at least as of right before I logged in for this webinar, we have no guidance yet from the Internal Revenue Service or the Department of Labor. All we have are the, paragraphs, and they're not many, in the CARES Act itself written by Congress. And so I will tell you what we know. I will tell you what I'm seeing. But there's still a lot of unknowns with these retirement plan changes. So the first ones I'm just going to briefly hit on are the changes for any of you that have a traditional defined benefit plan or a cash balance plan. There are some pension relief provisions in this. The first piece of relief is any required funding contributions that were due in 2020 are delayed until 2021, so they are providing some relief there. The second piece is benefit restrictions. Those of you, this will mean nothing to those of you who don't have a defined benefit plan, but for those of you that do, you're probably familiar with the term AFTAP. And your AFTAP percentage it's the adjusted funding target attainment percentage. It's calculated every year, and it's based on how funded your plan is. If it drops below, the funding level drops below a certain point, then you have benefit restrictions. For example, you can't offer lump sums at a certain point. And so due to the, market decline, vast market decline we've experienced this year, they're allowing plans to use their 2019 AFTAP for the entire 2020 plan year, so that a lot of plans that may have had suffered from benefit restrictions won't be subjected to them now. So that's all I'm going to talk about on defined benefit plans. The next slides I'm going to talk about defined contribution plans. The first one actually applies to both IRAs. So for those of you maybe that have your own traditional IRA, it applies to that. It also applies to your defined contribution plans. So 401k, 403bs, profit sharing. And so in what this did, so required minimum distribution, for those of you who don't know that acronym, is generally once you turned 70 and a half, it's the later, unless you're a 5% or more owner, it's the later of severance from employment or turning age 70 and a half in those plans, you must start taking required minimum distributions. They start by the April 1st of the later of those 2 dates, and then each year thereafter, you have to take a distribution based on your life expectancy. That changed under the Secure Act that was passed late last year to 72, but that isn't in effect yet. So right now we're still, people that in 2020 that would have had to take an RMD would be 70 and a half or older. And so for those individuals, the CARES Act waives RMDs for the 2020 plan year. They did the same thing in 2009 with the market crash. And so what this just means is they're not going to make employers take or employees take money out at the bottom of the market. So this appears to be optional, that a plan does need to be amended if you're going to waive the RMDs. However, I believe virtually every record keeper that we have spoken with is implementing this for all plans. Now, that's not to say they all are, but I know the largest ones are implementing this for all plans. There's no option to opt out of this. And quite honestly, I'm not sure why an employer would choose to opt out. You know, you don't, forcing an employee to take an RMD when their account has, you know, probably suffered a 20% hit this year, it's probably not what anyone's going after. So right now, these amounts, if an employee already took their RMD for this year, you can roll it back into the plan. It would be treated as an eligible rollover distribution. Right now, we believe it has to occur within 60 days of the RMD being taken. We're hoping that the IRS issues guidance that provides relief on that 60-day period. But if you have participants that have already taken their RMD and they want to get them back into the plan, they should act quickly in case that IRS guidance does not come out. So the next couple, so that was the first sort of major change in the CARES Act relating to defined contribution plans. The next three that I'm going to talk about all relate to the concept of a qualified individual. So it's important that we talk about what is a qualified individual. The definition, in my perspective, is really broad. The first two, there's three prongs to how you can be, and they're or prongs, how you can satisfy the definition of qualifying individual. The first is that the participant themselves has to have been diagnosed with either SARS, CoV-2, or COVID-19 with a CDC-approved test. So that's the first way you can be a qualifying individual. The second way that you can be a qualifying individual is if your spouse or dependent was diagnosed with any of those three with a CDC-approved test. And the definition of spouse and dependent here follows the 152 definition, so it would be similar to who you can claim as a tax dependent. The third prong, and this is the most expansive prong, is anyone who experiences adverse financial consequences due to quarantine, a furlough, layoff, reduction in hours, due to being unable to work due to a lack of childcare, or closing or reducing hours of a business for a self-employed individual. So we've gotten some questions on this. Does this just mean, but you know, I've had employers say, I've heard these provisions, they don't want, you know, we haven't done any layoffs. We're still paying people 100%. So my employees aren't going to have experienced an adverse financial consequence. You know, not necessarily true. I think quite honestly, most of us could say we have experienced some adverse financial consequence due to being, you know, quarantined or unable to work or, you know, due to childcare or you name it. Some commentators believe that it's the participant that has to be the one who was off of work. What if a spouse was laid off? I mean, you know, most people that have two incomes live off two incomes. And so, you know, that could qualify you for an adverse financial consequence. We're hoping that the guidance will clarify this. But what we're hearing right now is this was intended to be interpreted broadly. Also, an employee self-certifies that they are a qualifying individual. The employer does not have to make this decision. They don't have to make the determination. So unlike, you know, your hardship withdrawals, if you have those in, let's say, your 401k plan, the employer needs to certify, and you're supposed to collect some proof that the employee actually has, you know, medical expenses or is being foreclosed upon. Here, the employee just needs to self-certify that they qualify as a qualifying individual, and then if your plan offers any of these three options, they would be eligible for them, okay? So that is, remember, just these next couple slides only apply to qualifying individuals. So the first one, this is a brand new distribution right. It's called the coronavirus-related distribution. This is an in-service withdrawal right that would allow an employee to withdraw from their account up to $100,000 if they are a qualifying individual. Okay, that's all if your plan puts this provision into place. This is optional. It does not need to be added by a plan. But if your plan offers this coronavirus-related distribution, the employee could withdraw up to $100,000 from their account if they are a qualifying individual. So again, just the diagnosis would allow them to tap up to $100,000. How is this different from some of the other distributions we have? Well, first, there's a waiver of the 10% early withdrawal. So generally speaking, if you withdraw 401k money before you're 59 and a half, there's a 10% excise tax on it on top of paying your federal, state, and local tax. And so this is waived if the distribution satisfies the coronavirus-related distribution. Also, this distribution comes with a repayment right. The employee can choose to repay this to an eligible retirement plan within 3 years. If they repay it within 3 years, they don't pay tax on it. The next sort of favorable characteristic of this coronavirus-related distribution is that if the employee takes the distribution, the tax is automatically spread over 3 years unless the employee elects to have it all taxed in year 1. And so they get to spread the tax, and then if they, end up being able to repay it, they don't pay the tax on it at all. It's not subject to the 20% normal withholding. It'll be withheld at 10% unless the employee elects a different withholding percentage. Now, it is up to $100,000. We have seen some clients want to implement this, but they don't want to open up $100,000. They want to open up $10,000 or $20,000. Legally, you are permitted to do that. However, we have seen some record keepers not able to administer that. We have seen some that are, so you really need to check with your record keeper if you want to offer this, but you're thinking, whoa, I'd like to offer this, but I really don't want people draining, which will virtually be an entire account balance for many employees. And so you need to check and see if your record keepers have any limitations. To be fair to the record keepers, they were trying to get these up and running in days of this act becoming law. And so, if they had a year, they might have a lot more flexibility designed into their systems. But right now, I think they're all doing the best that they can do as well. So that's the first of the 3 of these sort of optional changes. The next relates to plan loans. So the plan loan rules still apply. The general plan loan rules, if your plan offers plan loans, an employee can only take up to the lesser of $50,000 or 50% of their vested account balance. However, a plan can be amended to increase the plan loan amount up to $100,000 or 100% of the participant's vested account balance if for those individuals that are qualifying individuals. So if you have plan participants who do not meet the definition of qualifying individual, they're going to still be subject to that lower cap. But if you choose to, you can amend your plan to increase the $50,000, 50% to $100,000, 100%. This is only applicable to loans taken within 180 days of passage of the Act, which is September 22nd of this year. Okay, so we're seeing some people do this. We're seeing other people take a wait-and-see approach. The thing here is these loans are going to need to be repaid. And your average employee may not understand what a $100,000 loan looks like. When you factor interest in and the fact that this needs to be paid back over 5 years, that's around a $2,000 per month pay. That's probably over 50% of someone's gross, of their net pay that makes around $50,000. 50% of their take-home pay will go to pay back this loan. So, we've seen some employers not offering these to sort of protect employees from themselves. Really, though, I'm not trying to convince you one way or another. You have to make decisions, and a lot of times the decisions will be made based on what you're doing with your employee population, and we're seeing a lot of employers take wait-and-see approaches because maybe they're not having to do mass layoffs or leaves right now, but they may need to 3 or 4 weeks from now. Or they may be doing, more significant furloughs then. So it isn't a one bite at the apple. If you opt out of these things now, you should be able to opt into them later. But again, it's important to check with your own record keeper on those things. The final CARES Act thing that we're going to talk about is suspension of loan payments. The CARES Act says that plans can provide that any plan loan payment that is due between March 27th, the date the act was signed into law, and December 31st of this year can be suspended for a 1-year period. This actually, a lot of plans already have a 1-year suspension for leaves of absence. However, it doesn't extend the term of the loan. So a 5-year loan still has to be paid within 5 years. Here, the suspension period, so this sort of 9-month period gets tacked on. So if someone took a loan tomorrow, their period, would be the suspended period for the rest of 2020 plus the 5 years. So that loan would really probably be due at the end of 2025. Again, these changes are optional. The CARES Act does provide a special amendment deadline. The amendment deadline for these CARES Act changes is the last day of the plan year beginning after January 1st, 2022. Okay, so for a calendar year plan, you don't have to physically amend your plan document until December 31st, 2022. That being said, decisions are being made right now. These are all temporary relief. I'm not sure I said on the corona-related virus distribution, those distributions, that right is only for distributions made before December 31st, 2020. Okay, so these are temporary, so decisions are being made right now. Operationally, you need to know what you want to do to then we can document it in your plan document later. So then I get the question, what notification, if any, do we have to give to our participants? As of right now, legally none. A summary of material modifications or an SPD does need to be provided, but that deadline is 210 days following the end of the plan year for which the amendment is effective. So technically you have some time until July of 2023 for a calendar year plan to get your SMM out. Now, is that helpful to participants? No. So we are drafting employee communications for people and less formal type of communication to go out for those employers who are adding these to their plans. And record keepers may be able to, they may have pre-produced pieces as well. Okay, so those were the CARES Act changes. I am going to talk about some other changes and impacts on retirement plans. So some of these aren't changes to the law at all, but rather just things that we're seeing and considerations as we're going through this pandemic together. So the first one actually, though, is a change in the law. So for anybody who sponsors a 403B plan, a pre-approved plan document, those are, our first pre-approved 403B plan documents were supposed to be executed by March 31st of 2020. They have moved that date to June 30th, 2020. We have actually had a couple of clients take advantage of that delay because as people were working from home and dealing with their own, trying to figure out how they were going to stay afloat during all of this, signing that 403B plan didn't seem like the most important thing. So if you have a 403B plan, you have not signed your restatement yet, you have until June 30th. Similarly, for defined benefit pre-approved plan, the deadline was supposed to be April 30th, and you now have until July 30th to execute your restatements there. Okay, hardship withdrawals. If your 401k plan has a hardship or your 403B plan can offer a hardship withdrawal feature. This is an in-service distribution right that allows an employee to access money if they've had a variety of different hardship circumstances. The IRS has a safe harbor. It used to have 6 hardship provisions, so things that an employee would be deemed to have a financial hardship if they satisfied one of these 6 conditions. In the Bipartisan Budget Act of 2018, they added a 7th condition called the FEMA disaster. And if your state has been approved as a FEMA major disaster, then you are eligible for this FEMA hardship withdrawal. So I'm not going to get into the weeds on this because it couldn't be sort of a more egghead, only the true, really nerdy EB brainiac. People want to debate whether all states have been approved by this or if another step has to occur yet. And the record keepers are taking different positions on this. So what I would tell you about this is check with your record keeper, see if your plan has implemented the FEMA disaster for the hardship. Those amendments didn't have to be done until the end of 2021, so your plan document likely isn't going to show you. Operationally, see if you've implemented this, and then see what their position is if they're approving people for these. Quite honestly, if you're going to add the corona-related virus distribution, that's a must. If that's in your plan, and your plan also has hardship FEMA disaster withdrawals, the corona-related distribution is more beneficial for an employee to take because It's not subject to the 10% excise tax where this is, and a hardship has no repayment right, and it can't be spread over 3 years where the coronavirus-related distribution can. We get a lot of questions on can employers suspend contributions mid-year. There are a lot of it depends answers there. The first is, are you safe harbor or non-safe harbor? If you're not a safe harbor 401k plan, then you need to look at your document. Is the contribution discretionary or is it fixed? If it's discretionary, then you can cease it at any time. If it's fixed, you can only cease it on a going forward basis if anybody has already earned the right to have it. So what does that mean? If you're making it payroll by payroll, or if your plan does not have allocation conditions, so if it doesn't have a last day of the year or 1,000-hour requirement, then employees have already earned the right to that contribution, a fixed contribution up to this point. So you could only do that going forward. So if for a non-safe harbor plan, you really want to look at your plan document. You want to see if you have allocation conditions to see if you can only do it prospectively or if you could do it retro to the first of the year. It's a little more complicated if you have a safe harbor 401k plan. The IRS has loosened up the rules here in the last few years on when safe harbor contributions can be suspended mid-year. So some plans may be able to do this. You either have to make sure that your notice provided that you have the ability to reduce or suspend mid-year, or your company has to be operating at an economic loss. And there are some regulations on what economic loss means. I don't believe just be at your judgment call. You have to give a 30-day advance notice. That means you can't cease it effective today. If you got that notice out today, you could do it 30 days from now. You must make the contribution all the way up to that when that 30-day advance notice requirement kicks in. So you can't, even if you make the contribution after year end, you're still going to have to make it for this period up to the point where you have amended your plan. But you are subjecting your plan to the ADP and ACP test, if applicable, for the entire plan year. So even though you had to make the safe harbor contribution for part of the year, you're subject to the ADP test for the entire year. So another item that we wanted to talk about here is the partial plan termination, because we're getting some questions on this as well. What is a partial plan termination? Well, what this means is if your plan is deemed to have partially terminated, then you must vest at 100% all employees that had a severance from employment during this period. There's a presumption that if you terminate over the course of a plan year, 20% or more of your employees, you've had a partial plan termination. You're looking at employer-initiated terminations here. So employees who quit, employees who may pass away or leave due to disability, they can be taken out. Also, there is a way to factor in your normal turnover. This is a calculation you're going to need to do if you think you're anywhere around this 20%. So if you're doing a layoff or a reduction in force, it's really important because that you know that you should be vesting all of these employees. You don't have to vest everybody else. So your employees that continue to work are not going to need to be 100% vested, but those that had the termination do need to be 100% vested. Okay. And then the last thing I was going to talk about today before we take some more questions, this isn't really retirement plan related, but it's sort of its own benefit. And I have to be honest, I find this almost comical that this is the time that Congress chose to implement a student loan repayment benefit. So we've had employers begging for years to be able to offer a tax-free student loan repayment benefit to their employees. We were in a time the last several years where a lot of employees were really trying to attract and retain talent. It was the employee job market. The employers were struggling to with unemployment so low, and so they wanted to offer another form of benefit. They wanted to be able to help, especially millennials are coming out with more student loan debt than any generation before them, and so they wanted to help find a way to help millennials pay down their student loan debt. Employers can do it. prior to the CARES Act, they could do it, but it would be a taxable benefit to the employee. Some employers have gotten creative with things that they're trying to do in their retirement plans, but we have no applicable guidance on point outside of one private letter ruling there. So employers are taking some risk when doing that. And so employers have been begging for this benefit, and we finally got it. So that should be a good thing, right? The reason it doesn't feel that great to me is that it was put in, the CARES Act put it in as a temporary benefit. And so this is only for benefit payments that are made as student loan repayments before 1/1/21. So this year, just this year. And I think most employers, it's almost embarrassing to me. I don't want to reach out to clients who have wanted to, who have asked me about offering one of these benefits before, as the day before they may have called me about, needing to lay off or furlough part of their workforce. And so, they would say, like, have you lost your mind? Of course, we're not going to offer this we don't have cash to offer this new benefit. We're trying to figure out how to continue to offer health insurance right now. But for those employers who maybe are not suffering adverse financial consequences as a result of this pandemic, I wanted to bring it up to you. And so what this is that employers can, just this year, offer a tax-free reimbursement to an individual of up to $5,250 relating to student loan repayment. This counts for principal and interest payments. It can be paid a reimbursement directly to your employee, or it could be paid directly to the student loan company. In order to do this, you'd have to either draft or amend your 127 plan. The 127 plan is the plan that allows for educational or tuition assistance. So hopefully, if you're offering educational assistance already, you already have a Section 127 plan document. And so then you would just need to amend that. I want to note that this isn't an additional $5,250. So if an employee is already taking advantage of educational assistance, it's a total of $5,250. So let's say you were going to offer this benefit and you already offer educational assistance, and you have an employee that was finishing up their degree this semester, and so they had already received let's say $5,000 for their class this semester. They would only have the $250 left over if they had to start paying their loans down this fall. So there is some hope that Congress will extend this, that this was just getting it in as a temporary benefit was a way to get it into the act, and maybe they will extend this in the future. But just wanted to let you know that this benefit this is a new benefit, a temporary benefit out there for those of you who are interested in it. Just want to give sort of a shameless plug for our blog. So we always maintain the Benefits Insight blog. You can sign up for it at that website. I know all of you are receiving Haran's blogs, and they're great, but if you want an additional resource as well, there's one. The firm has launched a COVID task force. You can find it, it's front and center on Graydon's homepage. This is not just benefit related. This is everything related to COVID. We have created a task force, I think, of about 20 attorneys, and we're posting content every single day, whether it relates to SBA loans, employment issues, are you an essential business, force majeure, contract clauses. So you name it. It's just wanted to give you one more resource to go to there. And then with that, I think, Paul, am I turning it over to you now if we have any questions on the retirement plan side?
Yes. So are there any questions right now? I don't see any questions, Lindsay. I have one as far as the partial plan terminations. For an employer that has 200 employees and another employer has 1,000 employees, we're basically talking about 40 or 200 respectively to trigger the partial plan termination. Is that correct?
Correct. So that is a presumption, Paul. It is a rebuttable presumption. So, but that's something you have to be able to stand behind, that it wasn't a partial plan termination. So the 20% is really sort of it's a standard that we use. And yes, it's not tweaked whether you're small or large. It's 20% of your workforce.
And switching gears a little bit, going back to the in-service penalty-free withdrawal that was implemented. A couple record keepers have adopted on an opt-out basis, and maybe committees for plan sponsors weren't able to truly address the issue and went ahead and let it go through. Is there an opportunity a week, 2 week, a month down the road to say, hey, we really don't want to offer this and stop the benefit if it automatically got implemented?
Yeah, great question. So we are advising against removing it at this point in time. There is no what we call 411D6, or there are some benefits that are considered protected in your plan. Once you add them, you cannot remove them. And in-service withdrawals generally fall into that category. So for example, if your plan allows age 59 and a half withdrawals, that withdrawal right can't be removed, at least in regards to any money that has been contributed up through that date. And so without additional guidance, from the IRS and the DOL stating that this can be removed and is not a protected benefit, once it's in your plan, we believe it needs to stay in. Now, it's just through the end of this year, but quite honestly, that's why the opt-out approach really sort of bothered a lot of benefits attorneys, and that people, they were getting, sometimes record keepers were giving days, literally days within this becoming law to make this decision when people are busy or may have missed. I don't know. I'm sure I'm not unique, but I get hundreds of emails a day to my work email alone. And so sorting through all of them, and it could be easily overlooked or think, yeah, I'll get to that from X record keeper in a day or two. Right now I'm trying to figure out how to get my, 400 employees working from home. And so right now, if this went into your plan and you don't want it in anymore, I would highly recommend that you speak with counsel before taking the action to remove it. Now, with the plan loans, that's not true. Plan loans can be removed. They are not a protected benefit. So if the $100,000 limit went in and you don't want to have the $100,000 limit in place, you could make the decision to remove that at any time. So that's a little bit different. Obviously, anybody who took a loan in the interim for that $100,000 would have the right to that $100,000 loan. You couldn't make them repay it, but for any new loans going forward.
Great, thank you. We do have a couple other questions. For changes to the 401k retirement, are the changes you are required to make based on what your plan document says, or do all employers have to implement those changes?
Well, so none of them are mandatory. So if your plan doesn't have loans now, it wouldn't have loans unless you added them. As far as I've seen, even the record keepers that are doing the opt-out, if your plan doesn't have a loan feature in it currently and you fail to respond, they're not going to opt you in and add loans, because your plan would have to be amended by the end of the plan year to add a loan feature. You just have a delay to add the increase until the end of the 22 plan year. So, yes and no. On a loan piece, if your plan doesn't allow loans, that's going to dictate it. You could revise your plan now to allow loans. But since these are all brand new rights, your current plan document isn't going to address any of these. And so the plan would need to be amended to add them. But again, we have until the end of 2022 to do that.
And Lindsay, correct me if I'm wrong, if someone wants to adopt the new loan rules, but they don't want to adopt necessarily the new in-service withdrawal rule, is that permissible, or do they go hand in hand?
So legally it is permissible. These are 4 separate things. However, operationally, we have seen some record keepers. Now, this is the exception, not the rule. For example, Tia Craft on the 403B side, they currently have an opt-all-in or an opt-all-out, with the exception of the RMD. They're implementing that for everybody. But otherwise, so some record keepers are saying right now it's all or nothing. Others are letting you pick and choose. Legally, they're all optional, and so you could pick and choose them. But you just, whatever you decide, you need to work with your record keeper to make sure that they can implement it.
So in other words, legally, one or the other or both could be adopted or ignored, but the record keeper may have its own operational aspects that they're applying that kind of, what do you want to say, contradict what the employer may want to elect. Is that a good way to?
They're operational, yeah, they're operational limitations that some record keepers have because they've just been, you know, scrambling to get this into play.
So
All right, Paul and Lindsay, we're at time. So I think that we can talk about what additional questions there are and how we can follow up with people after the webinar, if that's okay. We want to thank everyone. Yep, we want to thank everyone for your time today. We understand things are hectic, and we hope you have found these last 90 minutes helpful. If you have additional questions or need guidance or assistance with anything, please reach out to your team at Haran. Copy of the webinar slides will be available via email after the webinar. The webinar has been recorded as well and will be posted to our website. This webinar was approved for 1.5 SHRM credits, and those certificates will be emailed to you this week. As a reminder, Haran has a COVID-19 resource center on our website. It's a source for navigating all things COVID-19 related, including guidance, tips, updates, and webinars. There's also a link to Graydon's site on ours as well. Thanks again, everyone, for participating, and stay healthy.